Good afternoon, Advocate Malindi SC.
Good morning, good afternoon, CJ.
Yes. If you prefer the mask on, it's fine, but feel free to take it off if you're so minded.
Thank you, CJ.
Are you well, sir?
I'm very well, thanks yourself, CJ.
I'm very well, thank you. We've interviewed you before, and I won't take time with you. I think I'll hand over to the JP. Thank you very much. But before I do, may I have the names of colleagues who want to put questions to the advocate, please? Colleagues?
Muimang.
All right.
Singh.
Schlemmer.
Mpofu.
Thank you. JP?
Thank you very much, Chief Justice. Good afternoon, Nzele.
Good afternoon, Chief Judge President.
You were interviewed previously, as the Chief Justice says. You've also acted in a number of work areas in the division. All I want to ask you is, you are a silk, you've appeared in many of these high profile cases that are in the, have you appeared in the Constitutional Court?
I have not, Judge President.
Yes. What I want you to explain, if you don't mind, is I asked you to compile a list of judgments you've handed down since you started acting, and also reflect the dates when the matter was heard and reserved and when the judgment was handed down. The last part of your report shows judgments only. It does not have dates, but you say those were heard in the 4th term and delivered in the 4th term. For record purposes, you only acted for 2 weeks in that term. Am I correct?
Judge President, that extra list is judgments of the 4th term, 2020.
Yes.
That were delivered in April this year.
Were delivered, you mean this month, in April?
This month, actually.
They were heard when in the 4th term?
They were heard in between 30 November and the 2nd of December.
Right. And for completeness sake, in those 2 weeks you added in the opposed motion court, how many did you have?
I had in excess of 10.
And thereafter you then went into the agent court?
And thereafter I went to the agent court.
Right. That's quite a tough allocation, even for permanent judge standards, from opposed to agent, isn't it?
That is so, Chief Judge President.
But all of them have now been handed down?
They all have been handed down.
Thank you very much. And you regard yourself as ready than ever to be appointed permanently?
I'm ready to answer to the call that I make myself available.
Thank you very much, Chief Justice. No more questions.
Thank you, Judge President. MEC?
Thanks so much, Chief Justice. Good afternoon, Advocate.
Good afternoon, MEC Lesufi.
Are you well, Advocate?
I'm very well, thank you.
Thank you so much. Ever since I knew you, you have been on the side of the weak, the vulnerable, and protecting the rights of individuals across the system. And you are well known for that. The time that you have spent acting, do you think your presence have brought uncertainty to other people, or you have been welcomed?
My presence as an acting judge.
Yes.
MEC.
Amongst other judges. You are not seen as a deployee of some sort and therefore not being treated like any other judge.
My presence has been most welcomed by the leaders of the courts in which I've acted, and the permanent judge who's, that I've had occasion to act when they are in court. And I believe that my presence as an acting judge has been welcomed by those judges as well.
Well, we are well known within the circles of one political party in this country. And I know the last time you were interviewed, you indicated that you took a cool-off period so that you can concentrate on your legal matters. Do you think if we recommend you, you'll be in a position to handle matters fairly, regardless of where they come from?
MEC, it is 4.5 years since 2016. I'm therefore 4.5 years older. And it's a two-pronged answer. To those to whom it mattered that I applied after about a year of not renewing my membership to the ANC. They've had 4 years to consider and observe me if they have. And I believe that period is more than long enough to allay fears that I come here as being supplanted from the Tulu House. The second part, JP, is that I never believed that that cooling off period applies to me. And I believe it does not believe to assessors of judges who assess what their past political beliefs were and whether they are consistent with the values of the Constitution. Thank you.
Thank you so much, Chief Justice. Thank you so much, Advocate. Truly appreciate it.
Thank you, Honorable MEC. Honorable Moima.
Thank you, Chief Justice. Good afternoon, Advocate Malindi.
Good afternoon, Councillor, Commissioner.
The experience as a legal practitioner and having acted, and drawing from your experience, which was not very good, as a former Delmas trialist, how do you compare the philosophy that governed the courts then and the current philosophy that governs our court, that governs our courts post 1994? The second one, second question relates to the narrative that sometimes can be quite discomforting around accusation of courts or of our judges as being judicial activists. Do you think there is a cause for concern? Because even with the former president of the USA, Donald Trump, when he replaced the Chief Justice then, what he said is that he's not going to appoint a judicial activist because judges are not there to make law; they must implement. Likewise, with the Prime Minister of United Kingdom, when the Queen dissolved Parliament following the Brexit crisis, the courts set aside that decision. Do you think there is a cause for concern on the narrative of judicial activism? Thank you, Chief Justice. Thank you, Advocate Malindi.
Commissioner, first of all, we know, as judgments would usually say, that the Constitution provides a bridge from the old to the new. And in fact, there has been that bridge and it's firmly built. We come from a system where the choosing of judges was by the prerogative of the executive. That has changed, and that will not change in as far as things stand now. We now are selected by a panel of no less than 20 commissioners who assess our ability and our suitability, and therefore it's no longer the choice or the prerogative of the minister. That's the first thing. Secondly, the judicial activism we celebrated post-1994 because the apartheid laws were not pro the liberty of individuals, and we agitated for the judiciary to interpret the law to encompass international law and international customary law. We now are in a dispensation where the Constitution encourages judicial activism to the extent that the Constitution and the laws that give effect to the Constitution do not cover those areas in which our laws still fall short of giving freedom and liberty to the people. That is why we have in Section 39 an injunction that the Constitution or the judges must at all times interpret the law with a purpose of giving freedoms instead of taking them. And that interpretation will apply to questions of customary or common law. I believe, therefore, that there is a measure of activism that is encouraged by our Constitution, that where the Constitution and our laws fall short, international law may be looked upon as well to assist in interpreting the Constitution in such a way that it remains progressive and not regressive. I must say, therefore, that it is still a question whether with those sections in the Constitution that encourage activism, whether the bench can still go beyond that. And it is a matter of debate, but there is enough judicial activism to ensure the liberty of individuals.
Thank you, Advocate Malindi. Thank you, Chief Justice.
Thank you, Honorable Mwema. Honorable Singh.
Thank you, Chief Justice, and good afternoon to Advocate Malindi. It's good to see you again, even if it is virtually. I remember the last interview. I have just one question for you, Advocate Malindi. Over the past 10 years or so, I mean, you've indicated that you've held directorships and trusteeships and interest in business entities, about 35 of them. But at the time of this application, you've resigned from all of them but 3, and you've indicated that you will resign from the 3 should you be appointed. Now, the one area I want to question is, I remember in the last interview, you did say you was a trustee in a matter, in the Sequoia Family Trust matter, but you have resigned from those trusts. And now you also say that you may be cited in these matters moving forward. Do you think in any way this, if you are appointed as a judge, this will have any impact on you and on your position? Thank you.
I don't think so, Commissioner Singh. I have resigned, but as citations in matters would be, I remain cited in those proceedings, and I do not think it is a matter that will affect my standing as a judicial officer if appointed.
Thank you very much, Advocate Malindi. Thank you, Chief Justice.
Thank you, Honorable Singh. Prof.
Thank you, Chief Justice. Good afternoon, sir.
Good afternoon, Professor.
Would you mind sharing your judicial philosophy with us?
Professor, we live in a constitutional dispensation, and therefore our philosophy is mainly guided by the values and principles that are enshrined in our constitution. I remain committed to the advancement of human rights, and I remain committed to advancing the rights that we enjoy in our constitution to encompass other rights which we may not have encompassed yet in international law. And our constitution has, our country has become a signatory to many international instruments, and we have ratified them. I believe that our constitution has embraced philosophies and constitutional principles that place us in a situation where we can proudly say that, let's say me as an individual, that the Constitution has placed me in a way where I don't have to philosophize on any aspect of the law, because the Constitution has embraced all those areas of the law which require development, although there is room for philosophical development of the law in several areas.
Thank you, sir. On another point, I noted in your application that you sat as an arbitrator in quite a number of commercial cases. Do you think it is perhaps detrimental to the development of our specifically commercial law if one is to refer more and more cases on arbitration instead of to deal with the disputes before the courts? What is your view on that?
I do not think so, Professor. I think that arbitration is a very efficient and cost-effective manner of resolving international disputes, especially for those who can afford to pay for those arbitrators, because parties pay in those instances. I think that the rate of interstate investments and trade involvement requires speedy resolution as contained in many rules of arbitration. So I do not think that it will be a stifling method of resolving problems, but it will be ensure speedy resolution. And of course, courts still have a role in international arbitration where parties seek those proceedings to be reviewed for the grounds stated in arbitrations.
Thank you, sir, but that relates to international arbitration. What about domestic arbitration? Or were you just involved in international arbitrations?
I'm involved in domestic arbitrations mainly. And I think even in domestic arbitration, I think arbitration is the way to go, including mediation in those processes. I must say that at the beginning, there was a misgiving about the move to arbitration because it flourished at the moment that there was transformation of the bench, and without being able to put to you statistics, there was a perception, and I think it was an informed perception that arbitration was resorted to in order to avoid benches that are now populated by Black and women practitioners who historically were not considered to be familiar with commercial law. We have gone a long way since then, that we have practitioners, Black and female, very few female at all, who participate in those forums as adjudicators in arbitrations and mediation. It has become more legitimate recently than in 1998 when it was first muted into the first decade or so. So I am happy that arbitration is but one of those methods of resolving disputes. And I am aware that until recently, there were judges that were complaining that parties appear before them when they realized that a Black judge is presiding. They ask for an adjournment for an hour, come back and say they've decided to go to arbitration. So that stigma of Black people as not being competent to deal with arbitration matters still exists. But as a principle, and as the commercial world now demands, arbitrations and mediations are more legitimate than they were some 2 or 3 decades ago. And I would say I support arbitration and mediation. And I believe that courts will ensure that they stand at the same standing as arbitrations, so that there isn't much choice between litigants as to whether they go to a conventional court or whether they go to arbitration. And whether they go to arbitration will depend on the arbitration clause that they have fashioned, especially if it's international arbitration, as to whether which court should jurisdiction over their matter. But definitely for domestic arbitrations, I believe courts should remain the primary forum that we go for resolving our disputes.
Thank you. So CJ, if I just may have a follow-up question. It deals with the question of the publicity given to arbitration awards. My question related specifically whether it isn't detrimental to the development of commercial law if disputes are taken on arbitration, and it's due to the fact of the confidentiality of the awards. If you could perhaps just deal with that part of the question.
Does it go to his suitability, Prof? I'm just trying to balance time, the upcoming meeting, and the need to test the suitability of a candidate for what he has applied for. Would you say it goes for suitability, or is it just out of curiosity?
It was basically to see what his position is on the resolution of disputes and what the easiest way is and most beneficial ways for the South African court law to develop. But if you don't want to allow it, that's fine. Thank you.
No. If you feel strongly about it, go ahead, Prof. I was just cautioning.
No, that's fine. I can live with that. Thanks. Thank you, sir.
Thank you, Prof. Thank you. Advocate Mpofu SC.
Thank you.
May I also add my name, CJ?
Go ahead, Advocate. I have President Maya.
Okay, thank you, CJ. Good afternoon, Senior Counsel.
Good afternoon, Commissioner Mpofu.
Thank you. I'm going to ask you about, thank God you're the last person I have to declare that I know for a long time. I've checked the list, but I think I must put that on record. But I've known you for more than 35 years, I think. Now, the question that I'm going to ask you has to do with something that I feel gets neglected a lot, and it is about judicial temperament, which is one of the requirements for a good judge. And I'm asking you specifically this question because of what I've just said. Having known you for more than 35 years, I've never seen you or heard you raising your voice at all, not even once. I don't know how you survived like that. Yeah. But, yeah. But and yet you are a very effective person and with strong views. Now, the reason why I'm asking you in particular is because you probably, as a Delmas trialist, which is where I met you, you probably were exposed to one of the worst forms of what not to do in respect of judicial temperament, because of the relationship that the judge, who was a judge in your matter, how he treated counsel in particular, which was very, very bad. I think one of them, well, he reported twice to the Bar Council, Mr. Marcus SC now. And he fought with George Bezos, Chaskalson, and all the other people that we respect. To what, or how important is judicial temperament and the effects? One of the candidates this morning talked about being bullied from the bench. She was giving experiences from a woman's point of view. But what is the importance of this element, usually forgotten element of judge making, which is judicial temperament, particularly vis-a-vis treatment of counsel, treatment of people in the courtroom, making juniors feel comfortable that they're not going to be told that they're asking stupid questions and things like that. If you can comment on that, please. As I say, as someone who's a professor of temperament.
Well, Commissioner Mpofu, I think as we get received as acting judges, and as some get admitted as full-time judges, we should be educated on the importance of the role that we have to play as judges. We are one of the arms of government, which is regarded as so important that the other two arms of government that are elected choose to appoint some of the best practitioners who must carry along with them the best of professional conduct and integrity into resolving disputes between the state and its citizens and amongst its citizens. So it is required of those people to see the significance of their role, that it is not a personal attribute that they are being chosen to be judges. It is an acknowledgement that they must stand as the most upright, as the most understanding, as the most persons who, when they pronounce on their decisions, they are decisions that will be accepted throughout by the citizenry. And especially that judges' standing enhances what we now believe is the three arms of state in the modern state. So judges must see their role as precisely that they are chosen to be these persons who stand above petty squabbles where people are involved in a dispute, that they must rise above all of those, theirs is not to show off about their understanding or to throw around their weight when they are adjudicating matters, but that they are discharging a very crucial part in maintaining the triad, the state that stands on three legs like a tripod. So if judges are seen as bullying or unfeeling, unempathetic to the people who stand before them, they may easily lead to one of the legs on which the state stands on breaking or collapsing, discredited. And therefore, if that one leg of the tripod is disabled in the manner that you suggest, it undermines the whole concept of a state where we have the judiciary, the legislature, and the most revered state as the one that keeps the others in check and takes into account the views and grievances of others, having treated them with the dignity, respect that they regard, because they may impact on the two other arms of government. I don't know if that answers your question.
Yeah, no, it does. Thank you very much. Yeah. Now, the last question is about you've been involved most recently with the initiative of the formation of PABASA as a crucial part of the transformation of the profession, broadly speaking, not just the practicing profession, but the profession as a whole, including the judiciary. Firstly, can you just tell us why those experiences, what will you be bringing to the bench, given those your own life experiences, including that one? And that includes all the other life experiences of yourself as an accused in a long trial, as a prisoner on Robben Island, as a former president of NADEL, and all that. What will be the unique contribution that comes from those life experiences that you'll be bringing to our bench if you are appointed?
And Advocate Malindi, if you could just summarize, please,
yes,
so far as possible, just give us a brief response. Thank you.
Thank you, Chief Justice. Commissioner Mpofu, the formation of PABASA is but a drop in an ocean. It is an endeavor to create an environment where practitioners will feel respected, recognized for their ability. Secondly, for those who are not there yet, will be in an environment where they know it's an initiative of people who are not seeking assimilation into other structures that usually undermine the background of those people, either on the basis of race or gender, and that people will endeavor to achieve what they want to achieve, knowing that they are being intellectually and otherwise is appreciated. And I'm saying that it's a drop in an ocean, because we know as much as we endeavor to achieve that culture within PABASA, whether those people succeed depends on who control or who are the consumers of legal services. And at present, the majority of consumers of legal services are people who own the resources of creating a livelihood. In other words, I know you will say those who own the means of production, and those that control the networks of access to work. And we are not there yet, because a minority of us still owns the means of production, and therefore litigate on substantial matters to a very limited extent. So PABASA is great to be in, and other initiatives that we know about that collaborate with PABASA at various levels. We are giving skills to people so that they are not seen as incapable to deal with any matter. But at the end of the day, whether they get to deal with those matters depends on whether they have the necessary networks amongst the people who own the means of production and the people who are the consumers of legal services. Thank you.
Thank you, Chief Justice. Thank you, Advocate Malindi.
Thank you, Advocate Mpofu. President Maya.
Thank you, CJ. I won't be long. I was actually going to ask you about Papasa Council. First, well, I still have another question, but first, I'm very glad that you put your name forward again. It's not often that Black cells make themselves available for judicial office, and that is important. Now, did I hear you correctly when I thought you said you've never appeared before the Constitutional Court?
I have appeared before the Constitutional. I have appeared.
Oh.
Okay.
Oh, all right. I misheard. No, that is fine.
What I was saying, President, is that from 2016, when I was last here, I have not appeared before the Constitutional Court, but I must be mistaken because I think I appeared in the Steenkamp versus Edcom matter, which was post-2016.
That would have been only once. Has that been from lack of briefs, or what's the reason?
It is lack of opportunity to appear in that court, President.
All right. Thank you, Counsel. Thank you, CJ.
Thank you, President. Advocate Malindi SC, thank you, sir. You are excused.
Thank you, Chief Justice.